Dictation start. In this case, there was no eyewitness, and the prosecution case was solely based on circumstantial evidence. Full stop. It was contended that all the circumstances relied upon by the prosecution ought to be firmly established by evidence, and the circumstances must be of such nature as to form a complete chain pointing to the guilt of the accused. Full stop. The main point to be established by the prosecution was the accused persons were present in the hotel room at the relevant time. Full stop. The hotel manager had stated that CCTV cameras were installed in the boundaries, near the reception, in the kitchen, in the restaurant, and all three floors. Full stop. Since CCTV cameras were installed in the prominent places, CCTV footage would have been best evidence to prove whether the accused remained inside the room and whether or not they have gone out. Full stop. CCTV footage is a strong piece of evidence which would have indicated whether the accused remained inside the hotel and whether they were responsible for the commission of a crime. Full stop. It would have also shown whether or not the accused had gone out of the hotel. Full stop. CCTV footage being a crucial piece of evidence, it was for the prosecution to have produced the best evidence which was missing. Full stop. Court held that omission to produce CCTV footage, which was the best evidence, raised serious doubts about the prosecution case. Full stop. Para. In this case, the courts below ignored the conditions that are required to be satisfied in a case based on circumstantial evidence. Full stop. It was further held that the courts below ought to have noticed the faulty investigation and non-collection of CCTV footage, some details and lapses in the investigation. Full stop. Besides, the opinion of the doctors that the cause of death was asphyxia due to strangulation was not supported by the materials. Full stop. Upon consideration of the facts and circumstances of the case, the court held that the circumstances and the evidence adduced by the prosecution do not form a complete chain pointing to the guilt of the accused, and the benefit of doubt is to be given to the accused, and the conviction of the appellants is liable to be set aside. Full stop. Para. In so and so versus State of Karnataka, it was alleged that 17 persons having formed an unlawful assembly assaulted deceased with sword and thereafter threw her dead body in a hut and set it on fire. Full stop. The evidence of eyewitnesses was corroborated by objective finding of investigating officer and medical evidence. Full stop. They were acquitted by the trial court, but in appeal, the High Court acquitted 3 accused and convicted 11 of them under sections 148, 302, 307, 449, 436 and 201 all read with section 149, IPC full stop. While three of them died during pendency of appeal and hence the appeal against them abated full stop. It was held by the Supreme Court that the participation of five accused persons A1, A2, A4, A5 and A8 and their active roles in incident was established by two or more eyewitnesses, hence their conviction was proper full stop. However, conviction of two accused persons A6 and A7 solely based on identification by one witness only was set aside full stop. It was further held that there was no evidence to establish that the remaining accused persons A10 and A13 were members of unlawful assembly, their presence at place of occurrence as onlookers cannot be ruled out, hence they were given benefit of doubt full stop. It was further ruled that A12 was not named in the FIR, since he is also entitled to benefit of reasonable doubt full stop.